Hello, in this video we're going to look at unfair dismissal law in Ireland. I'm Tommy Miles from Employment Rights Advice, a specialist employment law consultancy based in Monaghan and serving all of Ireland. You can download the SlideShare used in this video. The link is in the description below. If you're new here, make sure you click on that subscribe button. Challenging an unfair dismissal, an employee's guide. Contents. Who is covered? What's the burden of proof? Written notice of dismissal. Notice of dismissal procedures. Justification. Time limits. Preparing the claim. Redress. Hearing the claim. Appeal and enforcing the award. And further info. Who is covered? In order to make a claim for unfair dismissal in Ireland, you must meet the following requirements. Are you an employee? The relationship must be one of employer-employee. Have you been in continuous employment with your employer for at least 12 months? Were you dismissed? Your employer may claim you resigned. If you believe that you were forced to resign, you may be able to claim constructive dismissal. Have you avoided an excluded category? What is constructive dismissal? The statutory definition. Section 1 of the Unfair Dismissals Act defines constructive dismissal as the termination by the employee of his contract of employment with his employer, whether prior notice of the termination was or was not given to the employer, in circumstances in which, because of the conduct of the employer, the employee was or would have been entitled, or was or would have been reasonable for the employee to terminate the contract of employment without giving prior notice of the termination to the employer. What proof is needed? In unfair dismissal cases, the burden is on the employer to prove that the dismissal was fair. In a claim for constructive dismissal, the burden of proof moves to the employee making the claim. That means that you have to prove that the employer's behaviour was unreasonable. This can require proof that you took every step available to you in exploring grievance resolution prior to resigning. You must show that it was impossible for you in all reasonable circumstances to continue in your employment. It is for this reason that resignation should be a last resort. Tests for constructive dismissal. If your dismissal passes either of these tests, then you have a good chance of succeeding in your action. The contract test. This examines whether or not the resignation arose as a result of a breach of contract by the employer. The reasonableness test. This examines the question, was the behaviour of the employer so unreasonable that the employee was left with no option but to resign? Excluded categories. The Unfair Dismissal Acts do not apply to employees in any of these categories. Age. If you are under 16 or excluded from the Redundancy Acts because of age or have reached the normal retirement age covered in your contract. Do you work for a close relative in a private house or farm where you both live? If yes, then you are excluded. If you're a member of the Defence Forces or a member of the Garda Síochána, you're excluded. Are you receiving full-time training or apprenticeship? If so, this is an excluded category. A county or city manager, the chief executive of the health service executive, an officer of education and training boards are excluded. If you're employed on a written fixed-term contract signed by all the parties with a clause excluding the Unfair Dismissal Acts, then you're excluded. If you work outside the state, you will be excluded unless you were resident in the state for the period of the contract or are domiciled in the state and the employer was resident in the state for the period of the contract. Statutory apprenticeship, dismissed within the first 6 months of the apprenticeship or 1 month after completing the apprenticeship, is an excluded category. Are you on probation or training at the start of employment of 1 year or less and written in the completed contract of employment? If yes, then you are excluded. Employees in training for qualifications as a nurse or other specified paramedical employment are excluded. If you are excluded because you are in one of the above categories, you may be able to bring a claim for unfair dismissal if you are dismissed in contravention of anti-victimisation, equality, anti-discrimination or similar legislation. The burden of proof. As a rule, the Unfair Dismissal Acts provide a presumption that every dismissal is unfair, unless the employer can show substantial grounds justifying the dismissal. You still have to prove the facts of your case. The burden then moves to the employer to justify the dismissal. Dismissals which are in breach of equality discrimination are automatically unfair and cannot be justified. Written notice of dismissal. Gather information regarding the reasons which your employer gave for your dismissal. Write to your employer requesting the reasons why you were dismissed in writing. Your employer is obliged in law to provide this information in writing within 14 days of your request. Notice of dismissal procedures. Did your employer follow the dismissal procedures in place? If there are no procedures in place, there should be. The Workplace Relations Commission's Code of Practice, Grievance and Disciplinary Procedures states that employers should have written grievance and disciplinary procedures. How much notice did you get? The Minimum Notice and Terms of Employment Acts 1973 and 2005 set out your minimum entitlements to notice. Justification. A dismissal may be held to be fair if the employer can justify it under the following grounds. The grounds for dismissing an employee in Ireland which are considered fair are the following: capability, competence, qualifications, conduct, redundancy, contravening the law, or other substantial grounds. Time limits. You must make your complaint with the Workplace Relations Commission within 6 months of the date of dismissal. The date of dismissal does not refer to the date that you left your employer's premises. It refers to the date that you stopped being employed by them. To calculate this, you must include the notice period to which you are entitled. Under Section 7 of the Minimum Notice and Terms of Employment Act 1973, if you accept payment in lieu of notice, then the date of termination of your employment is the date on which notice, if it had been given, would have expired. To be safe, make your claim well within the 6-month period. Preparing the claim. Gather the evidence, write it down. Make a note of everything that happened, everything that was said. Cover the who, what, why, when, where and how. Memory fades. You will need these notes to refresh your memory. Keep all documents. This includes your contract, any correspondence, written notice of dismissal, etc. Redress. There are 3 options open to you: reinstatement, re-engagement, or compensation. Reinstatement. Circumstances at work may have changed significantly, which may rule out reinstatement. The role may have been eliminated or carried out by someone with another position within the company. Re-engagement involves being employed in a position of equal status and pay. Compensation is the most usual remedy. You can receive up to 2 years' pay if the dismissal is held to be unfair. There is a duty on you to mitigate your losses. You must seek alternative employment. Hearing the claim. The adjudication officer can ask questions of each party and of any witnesses attending. He or she will give each party the opportunity to give evidence, to call witnesses, to question the other party and any witnesses, to respond and to address legal points. The Workplace Relations Act specifically provides that the proceedings will be heard otherwise than in public. Therefore, the adjudication officer cannot allow members of the general public, the press or observers to attend hearings. After the completion of the investigation, a written decision will issue within 28 working days or as soon as is practicable. Appeal and enforcing the award. Either party may appeal the decision in writing to the Labour Court within 42 days of the date of the decision. Decisions under the Equal Status Act must be appealed to the Circuit Court within 42 days of the date of the decision. If no appeal is lodged after this period, the decision is legally binding and may be enforced through the District Court. Unfair dismissal. Further information. Please contact us if you require any further information or help with your unfair dismissal claim. We have over 30 years' experience in employment law in Ireland. Our contact details are there, and you can also check the link in the description below for our contact link. So, if you feel you may have been unfairly dismissed, just click on the link in the description below and avail of our free unfair dismissal assessment.